I want to talk with you today about the Florida Evidentiary Code's treatment of privileges. And normally when we have these conversations, we juxtapose the Florida Evidentiary Code against the federal rules of evidence. That's not going to be as helpful for us today because the federal rules of evidence are remarkably silent when it comes to dealing with evidentiary privileges. Now, there's a historical reason for that. At the time that the Federal Evidentiary Code was being implemented, when the federal rules of evidence were being passed, we had a little thing going on called Watergate. And you had the assertion of executive privilege by then President of the United States, Richard Nixon. The Congress was unwilling to adopt a series of privilege rules during that time frame because of their fear that it might have an impact on their fight with the President of the United States over the assertion of executive privilege regarding the Watergate investigation. And for that reason, the federal rules of evidence pay a cursory, sort of a swipe at privilege, if you will. What they do is they define privilege as existing at the common law, the federal common law. Now, that's remarkably different from almost every other state code, and Florida is, of course, no exception. Florida has a well-developed series of evidentiary code applications for privilege, and we're going to go through them this afternoon. If you'll take a look at our slide here, you'll see that except as otherwise provided by the evidentiary code, statutes, or the Constitution, a person does not have a privilege to refuse to be a witness, to refuse to disclose a matter, to refuse to produce any object or writing, or to prevent another from doing so. So what does that mean? It means that as we begin to think about the assertion of privilege within the Florida courts, we start from the standpoint that all of us have a duty to comply with orders for production. Now, this is relevant in something as simple as a traffic hearing. If a judge asks for an individual to produce a document or a piece of information, well, they have a duty to do so, and absent a privilege, they're going to have to comply. The Florida Evidence Code itself has 9 specific privileges. What I'd like to do is to go through them with you. We'll start with the lawyer-client privilege. Now, we define a lawyer as someone who is authorized or reasonably believed by the client to be authorized in the practice of law. And a client is any person, officer of a corporation, corporation itself, association, or other organization that works with the lawyer and who consults with that lawyer for the purposes of obtaining legal advice. Now, a client has a privilege to refuse to disclose and to prevent any other person from disclosing the contents of confidential communications when such other person learned of the communication because they were made in the rendition of legal services to the client. What does that mean? It means that what the client tells the lawyer for purposes of legal representation can be excluded from any court proceedings by the client. In other words, the client holds that privilege. Now, you should keep this lawyer-client privilege separate in your mind from attorney-client confidentiality under the Florida Rules of Professional Conduct. It's an evidentiary issue, not a disclosure to the police issue. So basically, the client holds the key to the door of any statements that they made to the lawyer for purposes of representation. And if the client's not willing to waive that privilege, the evidence is not going to be admissible at trial. This is a statutory right. And by statutory, I mean, we take a look at the slide here. A communication between a lawyer and a client is confidential if it is not intended to be disclosed to a third person other than someone because of these issues, primarily them being what? So that we can properly represent the client. Now, the client holds the privilege. The lawyer has the ability to claim the privilege when they do so on behalf of the client. Let's shift gears here from the lawyer-client privilege and let's talk about public records and meetings in the state of Florida. You should all be aware with the Sunshine Law for the state. And the Sunshine Law requires that all meetings of any board, commission, or state agency or authority of a county or municipality or a political subdivision of the same, at which official talks are held, they have to be open to the public at all times. The minutes of the meeting must be properly and promptly recorded, and the records have to be open to public inspection. Communications made at these meetings, communications between the legal advice for those organizations and the organizations, the officers of the organizations, are by operation of statute not confidential. And because they are by operation of statute not confidential, they are not subject to the lawyer-client privilege. So if I've got a lawyer who advises a local city board, and in that local city board a discussion occurs and some facts are provided that are later determined to be useful in a court proceeding, the members of the board cannot assert attorney-client privilege in an attempt to prevent that evidence from being admitted. And the reason for that is the connection of that lawyer-client relationship to the Florida Sunshine Laws. And it's a statutory right. Now, there does exist an exception where we can, as an agency of the state or a sub-entity of the state, have a private meeting. And if you look at the list that we've got right here on the board, you can see when that occurs. If I have litigation that's pending and I'm meeting with the client to discuss that litigation, I give notice to the public that I intend to have this meeting. I have a narrowly tailored meeting, and it takes place with an open meeting. So, for example, I'd have the open meeting, then we go into a private session to discuss the legal issue, and then we would come back into the open meeting again, and I record the session. I record it, I transcribe it, and I file it. But it's filed under seal until such time as the litigation is concluded. If I've jumped through those hoops as they're described right here, I'm okay. And I can assert attorney-client privilege for that portion of the meeting with what would otherwise be considered someone who falls underneath the Sunshine Law. So we've talked about lawyer-client privilege, and we've talked about the privilege not applying to public records and meetings under the Sunshine Laws in the state of Florida. I want to turn our discussion now to physician-patient privilege. And we start with the idea that in the state of Florida, physician-patient privilege, as it regards to the admissibility of testimony at trial, does not exist. There is no physician-patient privilege in the state of Florida. It's not recognized under the Florida Evidentiary Code. What we have instead is a confidential relationship between the between the doctor and his patient that keeps that information silent until such time as litigation is pending. And I've got the language of the statute up right here for you. Medical records and the medical condition of a patient may not be discussed with any person other than the patient or the patient's legal representative or other healthcare practitioners and providers involved in the care or treatment of the patient, except upon written authorization of the patient. Now that's relatively clear. But if we look a little further down here, we see that these records may be furnished without authorization, i.e. authorization of the patient, when we have a subpoena for a civil or criminal action, when proper notice is given to the patient and the patient's legal representative by the person who's seeking to get the records. Well, what does this mean practically speaking? If I have a case before me as a judge and there exists medical records that might be useful for this case, whether civil or criminal, those records can be gotten at. They can be read, they can be reviewed by either party. Notice has to be given and a motion has to be filed. That's a common thread in many states. You won't find it within the federal rules at the common law one way or the other. Now, there is a federal psychotherapist patient privilege. And that federal privilege comes from a case called Jaffe v. Redmond. It's a Supreme Court case from the 1990s. And it defines the privilege as residing with a patient when we're dealing with psychotherapy issues. And a patient under the federal law has a privilege to prevent any person from disclosing confidential communications between the patient and the psychotherapist. Florida has adopted a similar rule, and it's a federal standard. So if I'm the patient of a mental health provider, I do have some ability to prevent disclosure. Now, that psychotherapist patient privilege here in the state of Florida works as follows. It's confidential as long as it's not intended to be disclosed to others. So you can give it to persons present, you can give it to patients, to others, to further the patient's interest. Normally that means doctors that we're consulting with to assist the patient for examination or for interview. Other folks to whom it's necessary to give the information. And that necessity may be by operation of law or by operation of filial relationship, and other individuals who are part of the treatment team. This psychotherapist patient privilege is different from the confidential nature of the patient doctor privilege, which does not exist in the state of Florida. It's a line that you have to carefully watch and address accordingly. I want to talk now with you about the marital communication privilege, which is here on our slide. A spouse has the ability during and after the marital relationship, so in other words, when you are married or even after you're divorced, to refuse to disclose and to prevent another from disclosing communications which were intended to be made in confidence between the spouses while they were husband and wife. The federal rules have a similar privilege under the common law, but in the federal rules, either party can waive the privilege. So the testifying spouse, for example, the person who wants to testify or who's been called to testify against another individual, can assert the privilege and waive it. Florida Evidentiary Code does not allow that. Either spouse who has the privilege can assert it and bar the other one from testifying in court. There are some caveats, though. And if you'll look here, this privilege does not apply when we have one spouse going against another spouse, usually in a divorce or child custody setting. In criminal proceedings, where one spouse is charged with a crime committed at any time against the person or property of the other spouse or the other spouse's child. Or a criminal proceeding where the communication is offered by a defendant spouse who is one of the spouses between whom the communication was made. So in other words, a defendant spouse could potentially offer that information to exculpate themselves when it revolves around a communication with the other spouse. Now, the federal rules of evidence do not have a journalist privilege. One has been created in the state of Florida that does apply. And professional journalists in our state have the ability not to be a witness concerning and not to disclose the information, including identity of a source, that they obtained while actively participating in the creation of news or the gathering of news. Now, this privilege applies only to information or eyewitness observations obtained. It does not apply to physical evidence, things that they saw, or visual or audio recordings of crimes. So this journalist privilege here deals with identity and source of information, but not with substance of information. And that's a line that you can carefully draw when applying the journalist privilege in the state of Florida. It is qualified, and it can be overcome, but it's going to require a clear and specific showing. Well, at least in those instances where the publication itself does not waive the privilege. You've got to show that it's relevant, you can't get it from any other source, and there's a compelling interest for disclosure. In those set of circumstances, you're going to be able to force disclosure, and you're going to be able to get the identity of the information. It's doable in the state of Florida. I want you to note that there is no federal rule of evidence counterpart to the journalist privilege, and instead, in the federal system, we handle this as a First Amendment constitutional issue as opposed to an evidentiary question. I want to talk with you for a moment now about the sexual assault counselor patient privilege. This is unique to the state of Florida. Victims of sexual assault or battery have a privilege to refuse to disclose confidential communications made to a counselor or other trained volunteer, records made in the course of advising, counseling, or assisting a victim, or any advice given by the counselor or volunteer in the course of relationship. If you think about it for a moment, this sort of makes sense. If I have a victim of sexual assault or sexual crime, and we are attempting to provide counseling to that individual, we want them to feel like their privacy regarding what has occurred to them is going to be protected. And this privilege allows for that. Now, it doesn't mean that the privilege cannot be waived and the information subsequently used, but it gives the power as to whether or not to waive the privilege in the hands of the individual who had been abused. And if you'll think about it for a moment, that makes a great deal of sense. Now, some communications between a victim of sexual assault and their counselor really aren't intended to be private, and those can always be disclosed. If I have other people involved in the counseling that aren't the volunteer, that are not the counselor, but who are present when the counseling occurs, that's waiver. That's waiver of the privilege. Potentially there, I may be able to get it in. So who claims this? Well, normally it is claimed by the defendant, by the victim. Occasionally, the defendant may be able to assert the ability to get into these records, primarily when the defendant is alleging that someone else may have been the source of the sexual abuse, or perhaps the sexual abuse, the claim of abuse, is not valid, at least as to that defendant. We have a case in the state of Florida called Pender that deals with that. The defense has to show the material nature of this information, of piercing this privilege. It hasn't been overruled, but it has been criticized. There is no equivalent federal rule to this particular privilege. Let's talk about domestic violence advocates and their victims. Again, here in the state of Florida, we've carved out this exception for folks who work with domestic violence victims. We allow for the protection of their confidential communications, but we have some requirements. The domestic violence advocate has to be registered with the state, and it's very similar in nature, and you should think of it in the same way that we think of sexual assault counselors or sexual assault and battery victims. Again, no equivalent federal privilege. This is a continuing theme, by the way. You see within the Florida Evidentiary Code some common sense privileges based upon Florida's historical experience in the state court system. You don't have the analogous types of cases in the federal jurisdictions, and so you've never really seen the growth of these sorts of rules. Here we've got the religious privilege. We have a religious privilege in the state of Florida, and if we look at it, you have the privilege to refuse to disclose or prevent anyone else from disclosing a confidential communication that you have made to a member of the clergy in their capacity as a spiritual advisor. It has to be confidential in nature, though. This is recognized under federal common law as well. You may have heard it referred to as the priest penitent or the priest clergy privilege. The idea being that when you go to a clergy member to seek spiritual guidance, what you say to them should be covered under that particular privilege. Here's another privilege in the state of Florida that we don't have anywhere else, and it's called the accountant-client privilege. Communications between an accountant and the client are confidential if they are not intended to be disclosed to a third person other than folks that I'd have to give it away to in order to represent the client appropriately, and others that are reasonably necessary in order to effectuate transmission. So things like addresses and that sort of thing. Again, you see this Florida attention to a practice that is not present within the federal rules of evidence. Now, there are places where the accountant-client privilege doesn't apply, and I've got them here for you on the slide. When the accountant's services are being used to commit a fraud, when there's a breach of duty issue, and when I've got two or more clients and I need to communicate this information. Federal courts have consistently refused to recognize this privilege, but the state of Florida has done so. I guess the state lobby for accountants is much better than the national lobby for accountants. This privilege here the accident report privilege is a statutory privilege, and it provides for the ability to suppress statements made to a cop. Statements made to cops are not going to be admissible in a civil or a criminal trial when they're made as part of the accident. Now, this presupposes that the privilege against self-incrimination has not been violated. Now, if the privilege against self-incrimination is not violated, the cop may potentially be able to testify about what was said, but otherwise not. The idea behind this is that we're going to give people the ability to prevent the admission of statements they make as part of an accident report, because we want them to talk to police officers when police show up on the scene, so that we can ensure the safety of the maximum number of people within the Florida system. Well, that sort of concludes our discussion about the Florida Evidentiary Code as it pertains to privileges. When I come back to you next time, we'll talk about a different subject. We'll move on to looking at witnesses and the way witnesses are treated in the state of Florida.